In a recent video, I shared the excitement that I felt after winning in a hearing and defeating a government's motion to dismiss to help my client whose immigration case was long delayed. Now, in this video, I'm going to dive deeper into the legal strategy that led to our victory. If you're passionate about immigration justice and you want to understand how the delay litigation actually works, you won't want to miss what comes up next. I'm Josh Goldstein. I'm an immigration lawyer based in Los Angeles. Our firm also has an office on the East Coast in Boston, and we help people across the country and around the world reach their immigration goals. And one of the obstacles that stands in the way of reaching those goals is the incredible inaction from USCIS, State Department, consulates, and embassies around the world. They're just not doing their job, and it's been going on for years and years and years. And one of the only things that you can do to actually get the government to do the work that they should be doing anyway is to file what's called a writ of mandamus lawsuit. And our office specializes in this. We file lawsuits against USCIS and the State Department because we care about you, and we want you to have a better future, and we want you to be able to get the visa and green card and student visas and so on that you deserve. In the short video that I made that got quite a bit of attention, I shared my excitement upon winning the hearing and defeating the government's motion to dismiss. And in this video, first of all, I want to talk to you about the legal strategy that we used. It was really quite simple, and we've used this successfully in several cases recently. The government's motion to dismiss was based on what we allege in our complaint. In our complaint, we say that the delay is unreasonable. That if someone's been waiting for years and years and years and they don't have an answer on their paperwork, that's not reasonable. The government is required to make a decision within a reasonable period of time based on the law. The government submitted a response in which they said that the delay was not unreasonable. And they cited to all this information about the pandemic and the backlog of cases and so on. And they included some affidavits. These are very boilerplate affidavits from someone who was supposed to have looked at a computer database that showed what a backlog is. And they made all these arguments. We refuted that by making one simple procedural claim. And that is a motion to dismiss under 12b-6 is based on the sufficiency of the plaintiff's complaint. And it's limited to the four corners of the complaint. You're saying in a motion to dismiss that the plaintiff has failed to state a cause that's sufficient. You're not allowed to bring in extraneous evidence and submit additional documents and affidavits. If you do that, it's not a motion to dismiss. That's a motion for summary judgment, which is different. That's the argument that we used, and that's the argument that has been winning in recent cases, which is a motion to dismiss is based on the sufficiency of the pleadings. You can't bring in extraneous evidence. So it should be denied, and it should be filed as a motion for summary judgment. Now, once you get a motion for summary judgment, it must be supported by affidavits that are based on personal knowledge. So someone with personal knowledge of the status of your immigration case must sign a sworn affidavit to support a motion for summary judgment, which is all fine and good. But as a lawyer, I have the right to cross-examine and depose and send interrogatories and really get to the bottom of what the witness is saying. So once they introduce a motion for summary judgment, they have to submit an affidavit based on personal knowledge, and that gives me the opportunity to embark on discovery. I get limited discovery, and I get to ask questions about the status of the application, and that's extremely powerful. And that's where we are now in the case. We have to talk more about the details of our client's case, because that's what this is all about. He filed an application for his wife in March of 2020, just as the pandemic hit. And here we are, well into 2023. His wife still hasn't even had an interview. And this has taken a tremendous toll on their financial well-being, on their emotional health, mental and physical well-being. It's unclear where this case is heading, but I can't wait to get more discovery so I can find out exactly what's going on. We've had several cases where the State Department has actually lost someone's application. They come back to us and they admit, like, look, we lost the case, can you resubmit these applications? The opportunity to depose a witness is unique. And it gives us the ability to unlock a lot of information that we can use in other lawsuits. And I'm really looking forward to doing that. But our journey doesn't end there. If you're looking for more inspiration and you want to hear the story about a family that finally reached its immigration goals with the help of a delayed lawsuit and how this happened, you do not want to miss this next video, which had me in tears. Check it out.